Are you Latanya Renee Bryant?
Yes, sir.
Okay. I have,
What sounds like a routine court check-in quickly turns into something much bigger. 3 separate indictments, multiple felony levels, and prior convictions that could change everything. The judge is about to walk through a timeline that raises serious red flags, and with every new charge, the stakes climb higher. This case isn't just about what happened once. It's about what kept happening after the court gave chances. Stay tuned, because this hearing escalates fast.
that's odd. There are indictments on different days. First indictment, April of this year, you were charged with a third degree felony of collision involving injury. And it is a third degree felony, which carries with it up to 10 years in prison. But in this indictment, as well as all the other indictments, the other two, the grand jury included in the indictments that you have prior convictions, 2 of them on 2000 and in 2009 out of the court next door, the 252nd District Court, for one for aggravated assault and one for delivery of a controlled substance. So if one or both of those were proven true, it moves or bumps up the charge. In this case, a third degree felony, it becomes a second degree felony. You're looking at up to 20 years in prison, and you are not eligible for probation in front of a jury. In 25 CR 885, this indictment handed up on July of this year alleges that you committed the second degree felony, God bless you, of aggravated assault with a deadly weapon on or about June 17th, 2025. And if convicted of this, it's a second degree felony, but which carries with it up to 20 years in prison. Okay, over there?
Yes, sir.
And because of the prior convictions that are alleged, the same aggravated assault and delivery, if all of that was proven true, you were looking at life imprisonment if found guilty of that. There's a third indictment, 25 CR 1110, which was an indictment handed up by the grand jury a month after the aggravated assault with a deadly weapon. And it alleges that you committed the third degree felony of evading arrest or detention with a motor vehicle. And those prior convictions are also alleged. So if you're found guilty, it becomes prosecuted and punished as though it were a second degree felony, up to 20 years in prison. So
Let's break this down, because this is where the gravity really hits. Individually, some of these cases start as third-degree felonies. But Texas law allows enhancements when prior convictions are alleged and proven. That's how 10 years becomes 20, and how multiple second-degree felonies plus an enhanced aggravated assault can expose someone to life imprisonment. The judge isn't speculating here. He's laying out the legal math. And notice the pattern he's emphasizing: release, re-offense, release again. At what point does the court say enough is enough?
importantly, what's the bond on the 885 and 1110? You know, they must be high. You're in custody. You hadn't been able to post a bond, and I think I know why.
30,000 plus no contact plus GPS remaining Jefferson County.
For what?
The 0885. I just thought that they went from 30,000. You said the 1110.
Yes.
10,000 with standard.
Who said that, Bob?
I have to look at them.
Okay, it wasn't me.
No, sir. The JP in the time, who's ever out of the jail.
They must not have had any clue about
Each one.
this first case that had been indicted, because you posted a bond in this first case on, or a bond was set by the magistrate on April. Then looks like there was a hearing on in May of 25, where the defendant it says
It's a forfeiture.
she wouldn't cooperate with the magistrate. So she was indicted and posted, and a bond was set in May. The next month, it's alleged she commits aggravated assault with a deadly weapon. And then that on 6/18 of 25, they take up a bond hearing. And then on June, I guess she's released, because in a week, she's committing a third offense of evading arrest or detention. She doesn't have a bond, does she?
The 445 is 16,000.
No, there is no bond. No, you don't have a bond. It is all revoked. You committed an offense, post a bond. A few weeks later, you commit a second-degree felony of aggravated assault, according to this, and post a bond. A few weeks later after that, you commit a third crime of a second-degree felony. And you are too dangerous to the community, and you're obviously you're going to stubbornly refuse to follow any bond conditions, which include the first thing, don't commit a crime. So you're not getting out until we can try these cases. We're going to try the most serious one first, get this first-degree felony out of the way, okay?
Yes, sir. Yes, sir.
Anything, Dad?
Yeah.
That's the rulings of the court.
By the end of this hearing, the court's position is unmistakable. Based on repeated offenses, escalating severity, and repeated bond violations, the judge determines the defendant poses a danger to the community and has shown an unwillingness to follow even the most basic bond condition: don't commit another crime. All bonds are revoked, and the court will proceed by trying the most serious charge first. This ruling sends a clear message about accountability and public safety. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.